Hello and welcome to the Deep Dive.
Hi, everyone.
Today we are taking a close look at a policy response that it's become a major flashpoint in American higher education.
Yeah, a really big one.
Executive Order 14188, officially titled Additional Measures to Combat Anti-Semitism. I'm Ethan Caldwell, and my focus here is dissecting the dense legal architecture and the specific mandates within this order.
And I'm Nora Harper, and I'm here to, zoom out a bit and unpack the immediate human context, the real-world consequences, and some of the really challenging ethical implications this order has sparked. Because fundamentally, this EO is an explicit response to that sharp surge of anti-Semitic discrimination, harassment, and sadly, violence that followed the Hamas attacks of October 7, 2023.
Especially across U.S. university campuses, which became a focal point.
Exactly.
So our mission today is to analyze the fine print of EO 14188. We want to show you exactly what specific actions it requires of federal agencies.
How it tries to use existing laws in new ways.
Right, how it attempts to kind of weaponize pre-existing civil rights law and why it generated such fierce controversy, leading to rapid legal challenges almost before the ink was dry.
Yeah, things move fast.
We want to give you a clear, unbiased look at what this policy is designed to do and, crucially, what it means for the boundaries of civil liberties in academic settings.
Okay, let's dive in. Where do we start?
Well, to understand the 2025 order, we really have to look at its foundation first. EO 15188 isn't completely new law. It explicitly reaffirms Executive Order 13899.
Which was from back in December 2019, right?
Exactly. That earlier order had already provided specific interpretive guidance, basically ensuring that American Jews were protected under existing federal civil rights laws, specifically Title VI of the Civil Rights Act, against anti-Semitic harassment on campus.
Okay, so it builds on something already there.
Yeah.
But here's where the political history makes this new EO so, provocative. EO 14188 includes some pretty sharp language, doesn't it? Claiming that the previous administration effectively nullified EO 13899.
It does. Claims they failed to give it full force and effect.
So kind of blaming the predecessors for inaction?
Precisely. So EO 14188 is framed by the current administration as a necessary measure to reassert and advance the original policy's purpose. It essentially says, look, the situation has dramatically worsened post-October 7, and we absolutely must act aggressively now.
And the order itself, it paints a pretty stark picture of the kinds of complaints it's responding to, doesn't it?
It does. It cites language describing Jewish students facing what it calls an unrelenting barrage of discrimination.
Things like being denied equal access to basic campus spaces, libraries, classrooms.
Yes, exactly. Libraries, classrooms, common areas. And beyond that, the order notes intimidation, harassment, and even outright physical threats and assaults.
So it's citing very concrete harms.
Very concrete. And the stated policy goal, which you find in Section 2, is clear and quite forceful. The United States must combat anti-Semitism vigorously, using all available and appropriate legal tools.
Vigorously. And what do those legal tools include?
Well, it specifies measures to prosecute, remove, or otherwise hold to account the perpetrators of unlawful anti-Semitic harassment and violence.
Okay, that phrase, prosecute, remove, or otherwise hold to account, that's exactly what raised the alarm bells among civil liberties advocates, isn't it?
Absolutely.
It doesn't sound like your typical Title VI compliance review. It sounds much more like preparation for federal law enforcement action directly on campus.
It certainly mandates substantial technical action from the executive branch. Section 3 sets forth a, frankly, remarkably tight deadline for government bureaucracy.
The 60-day one.
Yes. Within 60 days of the order's signing on January 29, 2025, the head of every executive department or agency must submit a comprehensive report.
60 days. That's almost unheard of when you're asking for a full strategic review across multiple huge agencies. Why such urgency, and what are these reports supposed to achieve?
They seem designed to create a strategic map, really. First, agencies must identify all civil and criminal authorities they have that could be used to curb anti-Semitism.
So potentially expanding beyond just Title VI.
Potentially. Expanding beyond the scope of the 2019 EO. But maybe the most immediate and strategic requirement is for an inventory and analysis of all pending administrative complaints.
The complaints.
Against universities.
Against institutions of higher education, specifically regarding civil rights violations related to post-October 7 campus anti-Semitism.
Okay, so that's not just, gathering data passively. That sounds like creating a target list, maybe under the guise of civil rights enforcement.
That's certainly the concern. By inventorying all those pending complaints, the federal government is arguably prepping for coordinated, maybe massive action against schools they deem non-compliant.
A very active stance.
Very active. And the Attorney General's report has to go a step further. It must inventory all related court cases against these institutions
Okay.
and indicate if the Justice Department plans to file statements of interest.
Which is basically the federal government stepping into private lawsuits. Exactly. It's a way for the federal government to insert itself into private litigation to push a specific policy goal.
Right. And what about the Department of Education? They're key here, too.
Absolutely central. The Secretary of Education has to analyze all Title VI complaints related to anti-Semitism, covering incidents not just in colleges, but also K-12 education.
Oh, K-12 as well?
K-12 too,
Okay,
yes.
well,
Any complaints pending or resolved since October 7, 2023, this looks like a full court press using the enforcement powers of Title VI.
which, just to remind folks, technically prohibits discrimination based on race, color, or national origin.
Correct. But it's being applied forcefully here to protect Jewish students based on that 2019 guidance, now supercharged by this new order.
It feels like really weaponizing Title VI.
That's the term many critics use. But if we want to fully understand the legal leverage being asserted here, we have to look at the most complex and arguably most controversial detail. It's in Section 3, subsection E, the immigration nexus.
Yes. This is where things get really complicated.
This is where the Secretaries of State, Education, and Homeland Security must coordinate.
And this is where we cross from civil rights law straight into immigration law, which is, a major red flag for a lot of legal scholars.
The coordination is aimed at developing recommendations. Recommendations for familiarizing universities with the grounds for inadmissibility under a specific legal code, 8 U.S.C. 1182A3.
Okay, what does that statute actually cover?
Well, the EO explicitly states that universities should be made aware of this specific code so they can monitor for and report activities by alien students and staff relevant to those grounds.
Monitor and report alien students and staff.
Yes, ensuring those reports lead to investigations and, if warranted, potential removal actions.
Okay, Ethan, we have to pause here and really explain what that specific statute, 8 U.S.C. 1182A3, actually means in practice.
Please do.
It deals with some pretty serious grounds for keeping someone out of the country or removing them, things related to national security and terrorism. For instance, it includes provisions about activity deemed harmful to U.S. foreign policy interests or involvement with designated terrorist organizations.
That's correct. So the criticism here is that the federal government is essentially encouraging or maybe pressuring universities to link the political speech and activism of non-citizen students and staff.
Speech which often includes anti-war or pro-Palestinian viewpoints.
Exactly. Link that speech to these very grave security-related grounds for removal.
Which critics of the EO claim is basically conflating criticism of Israeli government policy with actual anti-Semitism or security threats.
That's the heart of the controversy.
So this effectively means that non-citizens, we're talking green card holders, students on F-1 visas, visiting faculty if they engage in activism or speech critical of Israeli policy, they could suddenly face investigation, removal, denial of visa extensions.
That's the potential implication laid out.
Wow. This takes us way beyond just policy language. It becomes a direct, profound threat against international students and faculty, doesn't it? It fundamentally changes the risk calculation for any kind of dissent on campus if you're not a citizen.
And the real-world consequences, Nora, they started almost immediately. This wasn't a policy that just sat on a shelf gathering dust.
No, it moved incredibly fast. Just days after the EO was signed in late January, the Department of Education announced investigations into 5 major universities.
Including Columbia, Northwestern, UC Berkeley. Big names.
Right. This signaled that the 60-day reporting period wasn't just about gathering info. Enforcement was already kicking into high gear.
And the financial impact became very real, very quickly. It was, you could say, a crippling blow aimed at academic research infrastructure. Look at the action taken against Columbia University.
The funding withdrawal.
Yes. In March, citing these alleged failures to combat anti-Semitism adequately, the president decided to revoke a massive $400 million in federal grants and contracts.
$400 million. Ethan, that's staggering. The largest share of that, wouldn't it typically be NIH grants? For critical medical and scientific research?
That's exactly right. Highly competitive NIH grants often make up the bulk of that kind of funding. So it's not just like a fine, it's a devastating financial and infrastructural hit.
What message does that level of penalty send to every other university president across the country?
It demands immediate compliance, or seems intended to. The threat of losing federal funding, that ultimate weapon under Title VI enforcement, proved incredibly potent here.
But the ethical flashpoint, I think, goes beyond just institutional money, doesn't it?
It does.
Shortly after all this focus shifted to Colombia, Mahmoud Khalil, who was a prominent Palestinian student organizer and, importantly, a green card holder, a permanent resident, he was arrested and detained by ICE in March 2025.
That arrest drew massive national attention, primarily because the timing was so sensitive. It happened right after the university was specifically cited under this new enforcement regime. And our sources also cite a related executive order, EO 14161, which came out around the same time.
What did that one do?
It specifically prohibits non-citizens in the U.S. from holding, and this is the quote, a hostile attitude towards the U.S. government.
A hostile attitude. That sounds incredibly vague and open to interpretation.
It does. And this confluence of events, the main EO, the focus on Colombia, the Khalil arrest, and this parallel EO 14161 led critics to charge that Khalil's arrest was directly tied to his political organizing on campus.
Violating his First Amendment rights,
Yeah.
essentially, because federal policy was actively targeting political views.
That was the claim. For many, the link between EO 14188 encouraging monitoring based on security concerns and then the subsequent targeting of a known political activist felt like proof that the policy was, in practice, designed to suppress anti-war activism.
Especially activism from non-citizens.
This friction takes us directly into the legal counterattack and the highly polarized reception surrounding the order.
Yeah, the reaction was definitely not monolithic. On one side, you have groups like the American Arab Anti-Discrimination Committee, the ADC. They filed a major lawsuit calling for a nationwide injunction, basically asking a court to halt enforcement of both EO 14188 and that parallel order, 14161.
On what grounds?
They view this whole framework as an unconstitutional campaign against free speech. And significantly, their plaintiffs include international students and faculty who say they were targeted precisely because of their political organizing.
So a direct First Amendment challenge plus discrimination claims.
Exactly. Yet the order absolutely has its staunch defenders, people who point to the genuine safety crisis that many Jewish students were actually facing on campuses. Gil Troy, for instance, he's a presidential historian and a senior fellow at a Jewish Policy Institute. He praised the necessity of the order.
What was his argument?
He argued that many colleges had basically abdicated their legal obligations to protect all students, including Jews. So from his perspective, the EO was a necessary federal intervention.
Even if the execution wasn't perfect.
Right. He even conceded its implementation had been, quote, sloppy, but still felt the core action was needed.
So a defense based on necessity despite flaws.
But what's truly fascinating, I think, is the internal conflict this created within Jewish communities themselves.
That's a really important point.
Yeah, because while some groups absolutely celebrated the swift federal action as essential protection they had been demanding, others actively condemned the order. Some prominent Jewish voices and groups alleged the administration was using anti-Semitism as a, quote, guise for authoritarianism.
Wow. That's strong language.
Very strong. It created this deep schism, really, among American Jews regarding the policy's true intent and its ultimate effect. Was it protection or was it suppression using protection as a cover?
That division is critical. It really highlights how complex this situation is when civil rights enforcement, which is aimed at protecting students from legitimate hate and discrimination, has to navigate these incredibly sensitive areas of political free speech.
And the differential vulnerability of non-citizen activists.
Exactly. It's a tightrope walk, isn't it?
It really creates a paradox, doesn't it? The policy is intended, ostensibly, to ensure one group's safety and their access to education.
Which is a core Title VI goal.
Right. But its execution appears to critics to be leveraging the most precarious aspect of another group's status, their non-citizenship, specifically to silence their dissent.
So, to summarize our deep dive today, EO 14188 technically mandates a comprehensive and highly accelerated federal approach.
Definitely accelerated.
It collects specific, targeted data on anti-Semitism complaints and related legal actions, and it weaponizes Title VI authorities to prosecute anti-Semitism on campuses, building forcefully on those prior civil rights interpretations aimed at protecting Jewish students.
However, our analysis reveals this critical collision point. the legitimate, and I think we agree, necessary pursuit of protecting students from hate speech. It immediately runs headlong into fundamental questions about the extent of free speech,
Especially for certain groups.
especially for non-citizen activists. By linking Title VI enforcement, even indirectly, to those severe grounds for inadmissibility under immigration law, 8 U.S.C. 1182a3, the policy has created immense legal and ethical complexity.
It really has.
It shows how quickly policy intentions, even potentially good ones, can lead to really contested and difficult outcomes on the ground.
Indeed. And that leads us to our final thought for you today. When federal policy explicitly leverages immigration status as a tool for enforcing campus civil rights laws, we really must consider, how does this shift the nature and maybe the boundaries of political dissent for everyone, citizens and non-citizens alike, within an academic setting?
Something to definitely think about.
Think about that as you continue your own research into this critical and ongoing issue. Thanks for joining us on the Deep Dive.
Thanks, everyone.